Madam Chair, pleasure to be here. Like a good practicing lawyer, I'll try to speak less outside the courtroom. Uh, we stick to the brief. As you know, lawyers move from one brief to the other. The brief that is given to me today is riverine communities. And the question that I could formulate is that how do we now utilize the strength of riverine communities in the Brahmaputra basin to have a better stance in terms of what may unfold before us if the dam comes up. In retrospect, you see, we have talked about and recognized the rights of all other communities in India, including the forest dwellers. We now have the Forest Rights Act, but we have never thought about recognizing the rights of riverine communities. The case in point that I can tell you is we have got these thousands of islands across Ganga, 2,500 to be specific, and then hundreds and thousands of them on Brahmaputra. There is no accounting of the size of islands. Some of them may have been surveyed. Majuli for sure has been surveyed. Others may have been surveyed. But there are hundreds and hundreds of them. We don't know the kind of resources used, resource dependence of the communities over them, their vulnerabilities, so on and so forth. The point being this: if there is a good database of indigenous water rights in India, that could be a great tool to put forward in terms of the prior use rights of the riverine communities, especially the indigenous communities. If there is under international law any strong window and an entry point, it is the indigenous water rights and the bundle of rights that accrue from at least 3 conventions that are obligations both on China and India. So you've got your Convention on Biological Diversity that seeks to protect, and countries are under obligation to protect both biodiversity and communities dependent on them. There is Ramsar Convention, protect wetlands, protect communities under them. Both China and India are obligated. Your Stockholm Declaration, both countries have signed, are under obligation to protect what comes under it. And of course, your UNFCCC, which you can spin the other way, and I'll come to it briefly. So that's submission number 1. That a good database of resource dependence of customary, traditional, indigenous water rights is mandatory for us to have now, and that should be done. The second submission is that, let me also try and put this from a legal lens, that the discussions that we have been having since morning, let me try and put a legal lens to it from particularly 2 instances on which largely the water cases under international arbitration or disputes are argued. And this being legality and legitimacy. In terms of legality, there is in fact, strictly speaking, legally speaking, there is nothing that can stop China from developing this dam. It is within its sovereign rights to do it. Countries are free to utilize the resources that originate within their country and develop it the way they want it for their socio-economic development. However, this was held back in Lake Lennox case in 1957, but the principle got qualified later, and then it said that countries are free to develop it subject to the limitations of customary international law. Now, what is that customary international law, and what does that give us in terms of as a strategy, and what we got to do within it? That forms the component of what may be called legitimacy. So China may be well within its sovereign legal rights to develop the dam that it wants to, but whether this will stand the test of legitimacy under international law is to be questioned. And if the legitimacy is worked out to the extent that it proximately touches the legality and questions everything else, the very basis of the dam, the requirement that it is going to serve, versus whether it has the legitimate right to jeopardize the interest of downstream communities at the cost of. So the question being, can China meet its climate obligations by constructing a dam that jeopardizes the basic fundamental existential rights of downstream communities? If that question could be answered in negative, we probably have a good case in order to advocate it at the international level, and that legitimacy has to be done at a multi-track. You have to do it nationally, you have to do it regionally, and probably you have to do it globally. That may not stop China from doing what it is doing, but it might create a negotiating stance where you come in terms of how it could be done better by taking the best interest of communities into account. So that's submission number one, that how do we now build a case in terms of how legitimate is China's action in terms of using the hydropower for the purposes that it wants to, and how legitimate it is. The third submission is that, there's always this talk about whenever we are in South Asia, we always say China has not signed UNWC 1997 Water Courses Convention. Now even the UNEC Convention is also open for accession for other countries outside Europe. So that's probably a convention that has got a better visibility, it has got a secretariat, it has got a technical committee, so on and so forth. UNWC is without a parent, it's an orphan convention, so to say. It does have principles, it does have a procedure, it doesn't have a secretariat. It doesn't have a place, it doesn't have a repository. Where do you go to in terms of who do you talk to under that convention? China, by the way, was the only country, not the only, in fact, out of 3 countries, Turkey, Burundi and China, that opposed the convention. So taking recourse to the convention and thinking that if China signs the UN Water Courses Convention will give some relief is to be something which is kept at abeyance for now, for the life of this project and for the next ones. It will not do, it has not done, and you can infer it from the 27 treaties that China has with its upstream states, but none with its downstream states. So that's the China's treaty practice. You have to understand, China doesn't negotiate a treaty with its downstream. So therefore, taking recourse to the water conventions, the freshwater conventions, and a treaty is something that should be kept at abeyance as a strategy for the moment. That's submission number 3. There is something which is cooking up internationally, and that might be given a push, a diplomatic or a strategic push by India. These are called 2001 draft articles on transboundary harm or transboundary impacts of detrimental activities. There is a specific provision in that, and these are very similar to the articles that arose from, say, Helsinki rules that culminated into 1997 Water Courses Convention. There is a specific article in that says prior authorization and joint EIA. If this doesn't get adopted but gets the recognition and a UN push, it might create a kind of a soft power in the region in terms of what needs to be done by the countries that are having severe adverse environmental impacts. So here is 1 or 2 things that I think, and these are the last submissions, could be done. World is very quickly about to come up or launch a convention on delta management, sustainable management of deltas, Sundarbans and others. Deltas won't exist if mountains do not exist. Deltas happen only because flows happen. The sediments come in with water. These are not filtered waters that make deltas. So if that global India and others and other countries are to fulfill their obligation under the global convention on the delta, they need to protect the sources of water, which is Himalayas, which was talked in the morning. So probably a talk around a regional convention on the protection of glaciers in Himalayas could be a good diplomatic push in the region, that if we are about to protect deltas, we need to protect the glaciers. The third is that mainstreaming indigenous water rights and what this dam might do to them, people who have no recourse to any other water resource, could be a good instance to advocate in the region and beyond the region. And the third and the final being that there has to be a push for some kind of a more procedural exchange in terms of China's international obligations under conventions outside water convention. So in any case, this dam is going to take away the biodiversity, this dam is going to destroy the wetlands, this dam. So in terms of saying that we do not know the impacts, we certainly know certain impacts that dams per se pose. We can take you from many other big mega projects that happened in India, in the region outside India. And therefore, keeping that in mind, certain standard protocol in terms of procedural communication of the possible impacts could be done. Thank you so much.